Good evening, everyone, and welcome to our Justice and Pieces guest speaker series. Again, as always, the views are of the candidates alone. They don't reflect me, Justice and Pieces, Trials College, or any other education institution or affiliation. Again, I think it's important that we have these discussions so you can learn more about the different paralegal and lawyer bencher candidates and who you may want to support or who you may not want to support anymore. And today we're really happy to have Jahne join us here today. Jahne, maybe you could tell us a little bit about yourself. And thanks again for taking the time to talk with me.
Thank you, JP. So I've been a paralegal since 2011, and prior to that, I did my undergrad in paralegal studies. I have my bachelor's from Humber. After my undergrad and after getting my paralegal license, I did a postgrad in financial planning, and I did a subsequent postgrad at York University in dispute resolution. I also speak Spanish, French, English, and some Greek. Then that's my educational background. You might ask why my name looks like it's spelled like Jane. Background is half Greek, half Mexican. I was born in Mexico and came here when I was around 5 years old. I've been doing this I opened my practice in 2013, and I was one of the newer paralegals. I know I'm not the oldest, but I have seen the profession grow a lot, and I haven't liked what I've seen throughout my tenure as a paralegal. The scope hasn't really grown, and there isn't much to show in the profession. I know when I was in school that paralegals were a global focus, and Ontario was on the forefront because they've created a situation where there's an access to justice gap fill, if you would say. However, when I look at the numbers of paralegals practicing and paralegals licensed, there is an issue there, and I'd like to figure out what that issue is and how we can fix that.
All right, so perfect. Let's lead then into kind of the next question, which you sort of touched on there, is why are you running for bencher?
So, as mentioned, I haven't seen the profession grow in a manner that is sustainable. And in 2020, when Ontario shut down, I saw that most of the fields where paralegals are practicing are being ignored, and that touches on most Ontarians. The small claims court is one of the busiest courts in the country, and the tribunals are also extremely busy, and that puts Ontario's at the forefront. So when you have individuals whose cases are being ignored and you have higher courts proceeding, it's not fair for the public. And the Law Society isn't doing much about those issues, and they still aren't. The court backlogs and the tribunal backlogs are finally starting to make it to the news, but nothing was happening in 2020. Nothing happened in 21 or 22. So the LSO has a mandate. It's literally the second paragraph on their website that says that the Law Society of Ontario, it has to protect the public interest to maintain and advance the cause of justice and the rule of law, to facilitate access to justice for the people of Ontario. And they're not doing that. The people of Ontario are not large corporations going through Superior Court. That's a fraction of them, but the majority of them are the regular people that need to have their small claims court case heard or to have their LTB matter heard. WSIB, human rights. I have matters that were filed in the Human Rights Tribunal prior to COVID, and we still don't even have a date for a case conference or mediation. And there's the old adage of justice delayed is justice denied. So in 2020, when it was late October, there was a matter where the Superior Court asked me to attend and assist my client, and because she was having difficulties with her counsel. And this shared client was being forced to do a jury trial in the middle of a pandemic, and we couldn't even get a settlement conference by Zoom in small claims court. Yet they wanted to put 14 people in a room with a judge, court reporters, bailiffs, and witnesses, and the parties, obviously. But we couldn't even get in front of a small claims court judge. So I wrote to the administrative judge of the small claims court, who forwarded my correspondence to the Superior Court Chief Justice's office. I had retained counsel, and unfortunately, I did not end up suing, but matters started proceeding slowly. The reason I didn't sue is because both parties have basically conflicted each other out, and going to Superior Court against a Chief Justice does not make sense, especially when the Attorney General's office is telling you that it's their fault. The other issues that came across were that they didn't have the proper staffing in place. And when speaking with court clerks at the various courts throughout the province, it became apparent that people were leaving the Attorney General's office. And this is an issue which the Law Society should be dealing with. Why are people not wanting to work in the court system? So that is the main reason why I am running. My platform is basically twofold: to get the Law Society to do what it's supposed to do and to hire people to start lobbying the government if they have to, or start pushing them. The Law Society has enough staff to actually make movement. With the tree issues at Osgood Hall on the subway, they know how to make noise. They're just not making the noise required to do what they're supposed to do. So that's the main point. The second one is I believe that the Law Society has a conflict of interest in regulating paralegals, at least for the scope portion. And although I agree that it doesn't make sense to have various governing bodies with doing the same thing, the scope is an issue which the Law Society needs to realize it's in conflict in. Having lawyers tell us what we can and can't do is counterproductive and doesn't help the people of Ontario. And a simple solution to that would be to have a third neutral party run by the government dictate what the scope should be. They would know exactly what fields there's a need for paralegals in, and they can tell us where to go. Having the Law Society or us continue to fight is counterproductive because it's 5 paralegals, 8 lay benches, and 40 lawyers at convocation. Nothing will ever work out to provide paralegals an expanded scope if we continue to stay on that same model. So if you move the scope issue to a third party, it's no longer a question that the Law Society has to dictate. And they can still regulate how paralegals operate and the code of conducts, which they are known to do and should be experts in by now. So those are my 2 main issues. I have some other issues that I'd like to deal with. So one issue that I've noticed is a lot of court clerks and tribunal clerks are rejecting documents for no reason. And I believe that they're doing this because their name isn't on any of the documents. So if the Law Society asks them to take ownership of their documents that they reject by putting their name on it, then that might help in the basically rejection of documents, which is just adding unnecessary costs to the people of Ontario. Another issue is increasing the monetary jurisdiction of the small claims court. Currently, it's at 35,000. Alberta's been at 50 for the last couple of years. And we know that many of the tribunals pull their monetary jurisdiction from the small claims court. Currently, I have a bunch of matters in the Landlord Tenant Board where rent arrears are beyond the scope of the jurisdiction of the board. And a simple solution to ensure that the landlord is no longer prejudiced is to increase the monetary limit. The board, for some reason, isn't moving files as quick as they used to. So increasing the limit would protect landlords because at least they can get a judgment, even if it's just a piece of paper that says that the rent is actually owed instead of having no recourse at all. I'd also like to expand the scope of technology for paperless trials. It does help. We have so many requirements with the Law Society to keep documents, and keeping documents forever gets costly if they're in paper. Technology also allows us to speed stuff up at trials. So that's one issue I'd like the Law Society to focus on. Then there's the fact that we don't have an actual lobbying group. The Ontario Paralegal Association hasn't really done much. The board of that organization is in disarray given the messages I've been seeing on LinkedIn recently. I don't believe that there's an acting president, and there's question whether or not the deputy or acting has standing to even be the president. So if we can't contain what is happening as in our membership organizations to lobby for us, we won't get anything done, because the Law Society has a duty to Ontario and the paralegal associations have a duty to paralegals. And so I'm hoping that we can figure out a way to get an organization, if it's the Ontario Paralegal Association or something else, to be functioning properly. Then another issue I have is the fact that I have to carry $2 million of liability insurance. If I'm dealing with issues that are capped at the small claims court limit of $35,000, it doesn't make sense that I'm paying a deductible of up to $2 million, $1 million per claim, if the damage I can cause as a paralegal will never get there. It's wasted money. Right. So those are the main issues. The first two are that the Law Society has to start acting in the public interest, and that they have to acknowledge that they're in conflict, just providing the scope of paralegal practice.
Okay, so let's start. I mean, you raised a bunch of points, and you touched on it a little bit there with the Ontario Paralegal Association, right? A lot of what you said, without necessarily discussing whether, I think you'd get agreement, in terms of having trials and the landlord tenant board and the human rights tribunal, all of this proceed faster, having staffing in place. But is that better directed to, one, maybe rehabilitating? Again, I can't really comment on the state of the Ontario Paralegal Association. I'm not a member or knowledgeable of what's going on there, but let's take what you're saying to be true, that there's issues there and they are unable to, to effectively lobby on behalf of paralegals, whether to the Law Society or to the government, right? In terms of everything that you've mentioned, right? It should, from the paralegal interest, that you need to be doing these things. We need to have less delays. It's impacting your clients, et cetera, et cetera. But perhaps is that not more of an issue of getting better advocacy for paralegal groups rather than, say, the Law Society, whether as a venture or just generally, should be responsible to kind of fill in those gaps?
It's a mixed yes and no. Paralegals are hired to basically advocate for their clients. We are litigators by our scope. So to not have an organization that advocates is sort of counterproductive. And if we're going to, I believe that the Law Society doesn't have an obligation to do this, right? But if I'm a venture, I believe that I will have a bigger role where people would listen to me. So I'd have a platform where I can advocate for advocacy group. And that's why I'm including it in my platform here. If not, I agree with you. The Law Society does not have an obligation to be creating advocacy groups for paralegals. We should be doing that on our own.
So I guess in terms of if you're elected as bencher, then kind of how would you see that role, let's say, whether individually as an elected bencher or collectively as part of, the 53 benchers, in terms of addressing those issues that, largely are coming from, the government coffers, right? Whether they want to increase funding to the Ministry of the Attorney General, to the courts, legal aid, wherever, right? What can the benchers and the Law Society do? Or again, is this something that if you had stronger, in your words, sort of paralegal association or organizations outside of the Law Society to better effectively lobby, as you'd mentioned? Is it simply getting the benchers and getting the Law Society collectively to kind of go and reach out to the government, or is there anything more that can be done if you're elected?
So the Law Society should be worried about the delays, right? It's not appropriate. We see the College of Nurses and Doctors, and they're advocating for more money for their hospitals, for their family doctors. Yet the Law Society is not doing anything similar. We know that the governing body should be doing this. And if other professions are advocating for the people of Ontario, I don't know why the Law Society isn't. So in respect to what I would do as a bencher, I would raise the issue at convocation, and I would also continue to advocate by writing the government to do this. As a group, I don't know who my colleagues are going to be at the board. Currently, I know that Ms. Lamazo is running again. She's the only person who's there. I don't know her on a personal level, but what I've seen in the last 12 years has been nothing coming from convocation to assist the profession. And I'm sure that Ms. Lamazo, as the chair of the Paralegal Standing Committee, can educate me more on this point as to why nothing has been done to actively grow the profession scope. But right now, there is Ontario Paralegal Association and Law Society, and none of them are doing anything. Prior to 2020, when I started writing the government, I reached out to these organizations and I asked for help. And I didn't want to take this upon myself. But those organizations didn't do anything. So now we're at the point where this is a live issue. Scope is a live issue. And clearly the paralegals are not happy with the way things are being run. Scope is something that all of the paralegal bencher candidates are dealing with. And the fact that it hasn't been dealt with, and the fact that only around 35% of paralegals are actually practicing, is an issue that needs to be addressed. I'm not sure if I answered your question.
Okay, so let's talk about that, right? I mean, I think just today, in the Law Society of British Columbia, essentially passed, again, I'm not 100% sure on the details there, I think it's just coming out, but essentially that paralegals can be licensed and provide legal services, I think is sort of the framework in BC under, I think the government there looked at putting it under one regulator. So you're talking about scope and how this should be done independently, but meanwhile, that's kind of the same model that they're looking at. Again, I don't have all the details yet, but in British Columbia. So when you're looking at scope, and maybe you can expand more on what you're saying about a third party. So you're saying that the Law Society should regulate everything except for what paralegals can and can't do, and there should be like an independent body determining what you should be able to do. Maybe you can kind of elaborate a little bit on how, you're not talking about self-regulation like an entire, the Law Society, Paralegals Association or Paralegal Society of Ontario or something where they would just regulate yourselves separately. Maybe you can tell me a little bit more about that.
So the biggest issue where the Law Society has a conflict with paralegals is the scope. And currently, there's no point creating another body. Just like you said, in BC, they're putting paralegals under the Law Society. I saw the articles as well this morning. But they're going to try to follow a model like Ontario, so I'm guessing. The issue is, as long as we have a member organization with voting rights, paralegals will never be equal. And there's no point changing that if the only issue we can't agree on is the scope of what paralegals can and can't do. So when you remove the scope, the conflict is gone. Control of the scope. And if the control of the scope is now moved to an independent third party, directed by someone who's not affiliated with the Law Society, then there's no longer a conflict situation, and that person can look at where Ontarians need paralegals. There was the Chief Justice's report in family law a couple of years back that I don't know the exact percentage, but more than 50% of family litigants in Ontario Court of Justice are self-represented. And we got the FLP license, which isn't going to even be ready for another couple of years. I don't agree with how the license was drafted and what scope for family law was done. But if we have a third party deciding where paralegals should go or can go, you no longer have the fact that we have a conflict situation. I know that one of my competitors on this is bringing an action against the Law Society about immigration law. I applaud him. He's doing something. If that's the correct route or not, doesn't matter. At the end of the day, we shouldn't have to sue the Law Society to determine what we can and can't do, because that's counterproductive to the people of Ontario. And if you take that equation out of the Law Society's hands, it's no longer a question of, is there a conflict here? You're taking the problem away and people can't complain about it. We know that paralegals can do tribunal work, small claims, and provincial offences matters, and other issues in Ontario Court of Justice. But why can't we do more? In Saskatchewan, they're letting non-lawyers practice and do wills and do other issues, which we can't do here as paralegals. In Alberta, they're allowing paralegals to also come into play. They are limited licenses, but they're still doing something to try to fill the gap and assist the people of those provinces. Here, it's a debate, and it shouldn't be a debate. The focus should be the people of Ontario, not who should regulate what and whether or not it is an issue that needs to be dealt with.
Okay, so then what should be in this proposed scope, right, of what do paralegals need to be filling in, where there's apparently, as you're saying, a gap that is not being provided by lawyers, but could be provided by paralegals. And then how would you address, I guess, given the differences in terms of experience, licensing, education, what would need to be done, if anything, right? Because I have some of your fellow candidates who were saying, well, if we were given this scope with what we have, we should be able to practice it, right? Like immigration, we could do immigration board matters. So is there anything more needed than to be able to do the applications? So maybe first, let's break it up, and maybe you can first tell me kind of what are the areas you would see expanded scope that paralegals should be able to do.
So, sorry. So we know that there's a gap in family. Ontario Court of Justice has that shows at least 50% of applicants are self-represented. That only delays the court process and it hurts the people of Ontario. The other areas that I constantly get calls on is incorporation work or wills and estates. Not many lawyers practice in those areas, and that is something that this independent body can look at. Where is there a legal need? And the scope issue. Yes, family would be great for paralegals. We are litigators, as I mentioned, and we're used to dealing with individuals. But at the end of the day, the main areas are in family, I believe, because there is a hole there. I also get a lot of calls for criminal matters. I don't practice in criminal court. I do corporate bylaw offenses, but I get calls for criminal, and I believe that the scope there isn't wide enough to actually help the people that need assistance in criminal matters. Um, so I think those two areas are needed to be filled with a more cost-effective solution.
Okay, so for example, in criminal law, right? I mean, scope presently is certain summary conviction matters, where the maximum penalty is 2 years less a day. And earlier you'd mentioned again about the insurance, right? Like, why have $2 million in insurance? But again, obviously, if someone gets convicted for up to 2 years, there's a significant cost to them if it's out of an error by the lawyer or the paralegal. But in terms of increasing in some of these areas, so if you're proposing all sorts of criminal matters, indictable offenses like attempt murder, etc., what to kind of fill in any gaps in education, if anything, needs to be done, and then accordingly, how would that affect in terms of licensing fees, in terms of, as you mentioned, insurance, to kind of bridge some of those. And certainly we can look at it from the family law perspective as well, right? Is that, the biggest issue that I've heard from candidates about what happened with family law is, well, what are we getting? And how do we kind of remedy this with respect to opening this scope up, and what, if anything, we need to do in terms of education? Because again, some will say, we don't need any more education. It's no different than if you wanted to start practicing summary conviction criminal law, as you say, you don't practice in, other than the rules of professional conduct, you can start taking criminal clients tomorrow, right? How is that any different than if you wanted to start taking family law clients, again, given that your area of practice right now is completely different?
So in respect to that, I think the same applies to lawyers. Yes, you go to 3-year law school, and most of you have a undergrad degree and a master's usually, given the competitiveness of getting into law school right now. But not all lawyers will take a family law course, and not all lawyers take criminal. Actually, you probably all take criminal. But knowing that you're training your members properly is the biggest issue, I believe. And I know where I can go and find information. I'm not sure if all my colleagues do, but we should, because we all have the same training. So yes, our rules of professional conduct tell us that we can't take stuff that we don't know or are going to charge too much. So I think that there is that safeguard in place already. If, let's say, this independent body or the Law Society says we can start doing family in Ontario Court of Justice, we know that most support, and be a child or spousal, is regulated by guidelines, unless you have a Section 7 expenses, which deals with extraordinary issues such as extracurriculars or other matters. Then that falls outside of the table. But there's easy calculations in the jurisprudence to explain how to get to the right guideline amounts. And given that our field is to basically do research and advocate for clients, what changes from me researching a criminal or family matter at a higher level than a civil action in small claims court? I have the education to already do the basics. So what changes with the scope besides the address that I'm going to deliver the papers?
Okay, so let's kind of look at that scope there, and even transitioning to having this go to an independent body, or of course, whether the law study can look at that and perhaps expand it within themselves, right? Which is still a possibility, whether through a court action or through new benchers being elected. But in terms of getting some of this done, right? I mean, you do, as you pointed out, there's 53 benchers, 5 of them are paralegals, 8 are lay benchers, and then there's 40 lawyer benchers. Now you point out, well, hey, there's this inherent tension or conflict of interest, even though, I mean, all benchers, regardless of whether you're a lawyer, paralegal, or from the public, are looking at it from the public interest, right? So how are we going to convince, or how are you going to convince, 26 other benchers, whether they're your fellow paralegal candidates that are elected, or lawyer candidates that are elected, or general public lay benchers, to support either creating this independent body to determine scope, or alternatively to look at expanding the scope, saying, well, look, what we got in family law wasn't enough. We need more. What we need in criminal laws, you said, or immigration, or any other area. How is this going to be done with the current system that's in place?
That is a very good question. We've been regulated for around more than, like 15 years now. So there was previous paralegal benchers, and I'm sure that they've tried many things to expand the scope. So I would look at what they've done, see what worked, what didn't, in moving the scale, and expand on what worked. Also, the Law Society Act deals with basically how we're mandated. So the Law Society convocation does not actually deal with the Law Society Act that goes to Parliament. So if we can't figure out at convocation what it is that this independent tribunal should be looking at, or to fix the scope issue, then I would lobby the government and ask them to amend the Law Society Act to include that scope is regulated by a third party.
Okay, so kind of looking at that then, because earlier you had said, well, in the last 12 years, nothing is being done, right? So is that a product of, I mean, maybe you can sort of look at that, or discuss that kind of more of what should be done or what could be done. But again, as maybe you just point out, well, is it a question of all the previous benchers, the 3 election terms, right? Because this is the 4th one. What stopped things from being done? Is it the benchers themselves? Is it, did it go to votes and they were rejected by the convocation? But what is going to be done differently, if you and again, presumably for others that may share some of the points there about expanded scope, that can they do differently than, again, as you point out, well, what has been done in the last 12 years?
So as I mentioned, I don't know the previous candidates or the people who were there before. Did they try? I'm sure they did, right? The issue is you have 5 against 40. And if 40 say no, it doesn't matter what these 5 paralegal benchers did. A no vote is a no vote. And that's where we have the conflict situation. And until that is resolved, I can't say that my predecessors, assuming I get it, did anything wrong or right. It comes down to whether the convocation voted to expand the scope or not. And right now we know that they didn't. I believe that my predecessors had to do an alternative in creating the FLP license, but that doesn't help anyone. And until we realize that the Law Society has a conflict regulating scope, nothing will be done. And once that conflict is identified and agreed to, then I think we can move past the basics in the profession. Because currently, I don't believe that we even have basic rights in the profession. A simple issue is every time I go into court, I'm asked by the adjudicator, judge, or tribunal member if I have a license. Yet if someone says that they're a lawyer, they aren't asked if they have a license. So simple issues like that, not only are they demeaning, and your client ends up asking you if you have a license as well, but once we get past those basic issues, we can start looking at bigger issues. And we're not going to get there until the Law Society realizes its conflict with the scope of practice.
Okay, so let's look at that. I mean, is there in fact, as you say, there's a conflict? I mean, there is, for example, a group of candidates, both lawyer and paralegal, running, as a collection there, as a coalition. So, I mean, I think those candidates, your fellow paralegal candidates would say, well, I don't think there's a conflict here because they're in support of paralegals, right? I mean, is it just the people that have been elected benchers before that, or your position as well, any lawyer that becomes a bencher is inherently going to not support expanding the paralegal scope, right? Again, that sort of assumes that they're not running for the interests of public interest, right? I mean, as a lawyer myself, right? I mean, I would say that you can't assume that I wouldn't vote for expanding paralegal scope. I mean, again, my mandate, as you said in the second paragraph on their website, is in the public interest, right? So is there enough there to say, definitively that lawyers are not going to support paralegals, lawyer benchers are not going to support paralegals, and that's why we have to look at this independent body or government action? Or, I mean, is it just a byproduct of who may have been there, or perhaps maybe from their position it wasn't in the public interest because maybe there's issues of addressing, are they properly address the issues of competence, right? I mean, what can we say in terms of maybe who's run before and who may be elected? As you said, it could be anyone, any group, any independent candidate. 50 of you, 53 of you are going to form convocation, right? Is that, let's see how it works first before we look at some of these other options?
So, a couple of things. That group that you mentioned, I've gone through their materials and they don't actually have a position regarding paralegals and the scope. So I'm not going to put a position because they haven't made it known yet. I am planning on reaching out to them next week to figure out what it is that they're planning to do regarding the scope. Saying that all lawyers have a conflict is a bit extreme, and working in extremes never helps anyone. What I can see is every time the scope has been brought to convocation, it has been voted no to expansion. And that is a fact, right? We don't have an expanded scope right now outside of the FLP license, which is still not even in play. We have another 3 years for material to be provided. So going to the extreme wouldn't be beneficial to anyone to even discuss it because it doesn't help anyone. But what I can tell you is history dictates where the future will go if nothing changes. And if we continue to use the same rhetoric, basically, to try to change stuff, nothing is going to change. So something needs to change. And what's being tried in the past hasn't worked yet. So if it's creating an independent body to create the expanded scope, or trying different avenues at convocation, it has to be tried.
Well, I guess maybe this is a question for some of the current and past benchers, but I mean, have there been formal votes outside of the family law service provider that came out in December there? But has there been any formal votes where they looked at expanding, let's say, criminal law, or looked at immigration or divisional court, or anything? Has that ever come up in a vote that, again, you could point to and say, look, this is what we tried and the lawyers all voted against it, right? I mean, are you aware of any? I mean, I'm just saying, I'm not speaking from any knowledge of it, so I don't know one way or the other. But as a candidate, I don't know if you've either reached out to previous benchers, or looked at decisions at convocation. But have you seen sort of that sort of stonewall by the lawyers from things moving forward? Or do we have kind of a reason of what has, besides family law, what efforts have been made to look at expanding the scope so that we can learn from those and try things differently, as you're putting out here?
So I know a couple of years ago, I don't even know how many, there was a motion brought to expand the scope of family. and that motion was withdrawn. I don't know if it was ever put back on the table. Outside of that, I don't follow convocation steadily. That hasn't been my goal until 2020 when issues started arising for the profession. And those issues were made a lot clearer in 2020. And when I started looking at why it is that lawyers are operating and I'm running at a 90% loss on a month over month basis. And when you have, I had many colleagues tell me that they had to drive Uber during this time, and nothing has been done by the law society. Yet, that is when I started following the issues here. And that is when I started to get involved with the profession to try to improve it. I'm sure that most of my colleagues have started looking at this as well. But we have a 30% rate of retention for paralegals, and that is an issue. Whether or not it is an issue of competence that you mentioned, the Law Society regulates who is competent or not. And if they're not providing a situation where they're creating members who are competent, that's on them. And they should be changing that to see what they consider competent. They shouldn't be putting people through the programs to fail, because then we have a competence issue. And that is something the convocation does have the right to address. And the issue of competence shouldn't even be a question for expanded scope if they're saying you're competent enough to act in these small claims court matters. You mentioned that for criminal law, I can represent someone and they could possibly go to jail for 2 years. But why am I competent enough to judge someone's life for 2 years or advocate for them there? Yet I can't read a child support guideline in Ontario Court of Justice that doesn't even deal with property rights and figure out what a guideline interest or payment amount is for a single mother who is just trying to get child support. It doesn't make sense that she has to go and pay a lawyer when she can't afford it and her choice is self-representation or bankruptcy. That is the main issue here for expanded scope. The Law Society creates what it deems competent. And if it now has a question on what products they're getting, that's on them.
Okay, so then let's look at that issue, because that's a very important issue. Is, well, why are paralegals that are becoming licensed not then coming into practice or leaving practice? I think I don't have the numbers, but I remember former Treasurer Donnelly came and does a presentation at all the schools, and I remember asking essentially what's going on here, because that's concerning, right, for students that are looking to finish their programs and jump into this profession, that so many are leaving, right? So are you saying, is this something that can be solved with access to additional scope, or what more needs to be done to address the numbers there, right? Is it just like you said, there's maybe more areas, because if there's more areas, there'd be more money there, and more money there would equal to keep people in the profession, rather than, I don't know what the reasons they're leaving, maybe even conducting a study to find out what's going on there. But what can you say in terms of addressing that sort of gap there, and from licensing to 5 years down the road practicing and practicing successfully?
I remember when I was newly licensed for the first couple of years, I was getting surveys from the Law Society about my education levels, what I think would help me grow as a paralegal, and basically what I needed to help me grow. And I haven't received one of those surveys in around 6 years. So I don't think the Law Society is dealing with that issue anymore. And it should be. And asking members who are licensed what it is that they would need help with is important, right? Yes, we have to do an annual report, but if people are actually telling the Law Society in surveys that are confidential where the problems are and where they have basically holes in their education, they can address that issue. So I believe that the Law Society should start acting on reaching out to the members again, right? Sending out a survey is easy. I understand that they're going to need to analyze that data, but that can explain why they think we have a competence issue now.
Well, it's not necessarily a competence issue. It's just where are paralegals going, right? Or licensed paralegals going? If they're like, what are the barriers preventing them from staying in the field, right? Whether it's setting up their own paralegal practice or joining a law firm or paralegal firm or in-house or however to use their license, right? What is causing that deficiency, and what can the Law Society, whether in conjunction with schools or other sources, they're due to kind of keep them in the profession, right? Because if you're saying the reason is there's the areas that you can practice in are not as lucrative, then is expanding the scope going to address that problem? I mean, or is there something else that needs to be done to better improve the retention of licensed paralegals to practicing paralegals?
I'm sure everyone has their own reason as to why they're not practicing but are practicing. Expanded scope would definitely be one. One thing I do believe an issue is the lack of mentors available. I take on students, and the minimum requirement, I believe, is around 120 hours. That does not give me and a student the time to actually bond and make them feel comfortable enough to contact me if they have questions down the road. My program required that I do over 400 hours, and because of that, I'm still in touch with my basically, I don't even know what the word would be for a co-op or internship, my mentor in that role. So the fact that I had to work 3 months with this person created a more mentorship role where I'm more free to reach out to this person. But if you're coming to an office once a week for a semester, that doesn't help anyone. Half of the time they forget what they learned because it's once a week during their school semester. Or I believe that the internships are a waste of time and don't create a situation where they have a mentor. I've reached out to students, and some of them are in the field, but none of them feel comfortable enough to pick up the phone and call me. I'll take them out for lunch and stuff after the fact. I still talk to them, but coming in once a week does not give them they feel that they're still a student, basically. And by creating a situation where there's no mentors, and I'm getting this talking to colleagues throughout since I started running, they don't know where to go to ask questions. And I believe that that's one of the biggest barriers in this profession compared to lawyers, where they have a long articling period and know that they can reach out to someone because they've invested the time in them.
Okay, so the Law Society just doubled those hours from 120 to 240 hours. Now, I mean, that also raises, as you mentioned, lawyers. I mean, there's a whole debate before about whether those internships, which could last for as long as 10 months, should be even paid, or to even get minimum wage as a requirement there from the Law Society. But now, I mean, what about on the other flip side of the coin? There is, if you're looking at increasing the hours, as the Law Society has done, from 100 to 120 to 240, or as you're saying, well, maybe 400, for those students going through all those programs, to should it be unpaid internships that to get that mentorship, or again, if you're taking on a student, are you in a position with your practice to then be able to take them on and provide some kind of stipend or honorarium or minimum wage or whatever? But and also, the Law Society has a coach and advisor network, right? Is that something that they need to strengthen, get more mentors from the profession, or what else can the Law Society be doing besides, again, extending the length of internships and better promoting their coach and advisory network to look at providing mentorship and sponsorship for newly licensed paralegals to thrive and succeed in the profession?
So a couple of questions there regarding whether or not it should be paid or not. I leave that into any practice's own hands. I don't know their financial situations, right? If I take a student on, I do it in the hope that I can hire them after the fact because I'm investing time in them. Regarding what other people do, I can't speak to that. And I don't have enough information as to why they're doing this to give you an educated answer. Regarding the mentorship program, like I mentioned, I've been talking to people and I've asked them if they've reached out to the mentorship program. And a lot of the paralegals said that they have, and the responses that they got were not adequate enough to help them with the issue that they called about. And that is an issue that needs to be addressed, because if the Law Society is putting itself out there to create a mentorship program, it hasn't done anything to follow up to see if the program is working. And from my conversations with colleagues, based on those conversations, it's not working. And a simple example was someone reached out to the mentor program because they had their first settlement conference coming up. And they got a one-sentence reply of, "You can do it, good luck." That is not a proper mentorship program that should be dealt with by the Law Society. If someone is calling me for assistance on how to run a settlement conference, I'll spend the 10 minutes explaining what should happen at one of these hearings. It's not going to hurt me. And the fact that someone's putting a mentorship role on their resume alone with the Law Society is not sufficient to help the profession grow. And that is an issue that needs to be dealt with by the Law Society as well. Whether or not there's guidelines or trainings on how to be a mentor through that program, I don't know and I can't speak to that. But what I'm hearing from colleagues that have used it, it's not working.
All right, so the last couple of questions here. Again, for students that are listening, any advice that you can offer to them, any words of wisdom? And okay, let's go with that, and I'll ask the last question right after. So any words of wisdom for any of the students that are listening, because we're just talking about kind of the importance of mentorship, whether you're a student, newly licensed, or even practicing for many years. So, and thanks again so much for joining us.
So my advice to them would be to ask questions and don't be afraid to make noise. That's literally your job. A lot of the times I'll give students or new employees tasks and I don't give them all the information. And I wait to see how long it's going to take them to come and ask me for that missing information. Because that's going to tell me what kind of advocate there are in the field. And asking questions is our job. Learn to ask questions from your clients, learn to ask questions of your colleagues and your employers, because a lot of the times they have the information that can help you and will save you a lot of time. Learn to pick up the phone. It doesn't hurt you.
Perfect. So final question here. Elections coming up next month. Why should paralegals that are listening to this, why should they vote for you?
They should vote for me if they agree with what my positions are. Again, my position is that the scope should be expanded, that the Law Society is in conflict, and that the Law Society is not doing enough to advocate for the profession or the fields that we practice in. I also have the other 5 points that I want to touch on, but the two main issues that I want to deal with if I am elected is that the public interest is not being satisfied and the Law Society has a conflict and an independent third body should be dealing with their scope. If you agree with those points, vote for me. If not, there's other candidates who I'm sure are equally capable.
Perfect. So thanks once again for taking the time and joining us. For anyone listening, we'll go right on to our next one at the different link in a couple of minutes. Thanks again and all the best.
Thank you, JP. Have a good day.